So yeah, just want to welcome everybody to a Young Architects and Emerging Professionals Committee, our lunchtime presentation here regarding a really topic that I think that we need to be discussing more often, but contract fundamentals when it comes to being a young architect or just a veteran architect. Using owner and architect agreements is something that we don't really learn too much in school, but we need to learn it by doing and by failing sometimes in the field and in our practices. And so we have a great speaker today that's going to give us some insight as well as some practical knowledge on contract fundamentals. And young architects.
Yeah, got it.
Yeah, if you could just mute yourself for just a second, and then we can just continue on. But at Young Architects and Emerging Professionals, we try and give tours and events and continuing education for our young architects and emerging professionals so that they can be better equipped to enter in the field and start their practices as well as continue on their practices. And we've got a series called Becoming a Better Architect mentorship program. But this roundtable discussion or lecture series that we're doing today is a key component of what we represent for our membership and giving back and resources for being a better architect in the field. And so we've got Jonathan Rosardi here today, and he's going to present, like I said before, contract fundamentals, 10 key provisions in owner architect agreements. As I said, as architects, we focus mostly on design and our practices, but we don't really focus as much on laying the groundwork for our owner and architect relationships. So in this seminar, we're going to focus on that. Jonathan owns his own firm at Rosardi Law, as a boutique firm serving individuals and business clients throughout the San Francisco Bay Area. Rosardi Law works closely with its clients to understand their unique circumstances and needs, and to craft tailored and efficient and practical approaches to anticipating and solving problems. Rosardi Law is also frequently assisting clients regarding businesses, licensing issues, professional service agreements, risk management, and dispute resolution. The founder and our presenter today, like I said, Jonathan Rosardi draws on over 15 years of experience counseling and defending California professionals in their businesses. He began his career practicing with a large national firm in the city, San Francisco, and representing attorneys, judges, real estate, and design professionals and corporations. And we're very proud to have him here with us today. He graduated summa cum laude from University of San Francisco and from Moritz College of Law at Ohio State. Go Buckeyes. Welcome, Jonathan. How are you?
Yes, go Buckeyes. Thanks, Tim.
Yep.
Thanks very much for that intro, and thanks everyone for coming. I'm just going to share my screen here and bring up the slides, and we'll jump right in. And there is my contact info if you need it. And feel free to ask any questions in the chat, and I think the plan is to address those as much as we can at the end. I do have, it's called 10 key provisions. We'll try to get through as many as we can. I don't know if we'll be able to get through all 10, but the last few I intentionally made kind of what I view as maybe slightly less important than some of the ones I really want to get into. So let me see here. Okay, so just as an overview of what we'll be talking about today, first, just a little bit about the necessity of having a contract. Of course, under California law, unless it is exempt, architects are required to have a written contract with their client, and we'll talk about the exemptions. And then recommendations for contract format. This is just kind of a logistical issue that always comes up with my clients. What should my contract look like? How long should it be? I'm having trouble with the owner not understanding it. So some kind of tips for getting around those issues and getting something together that really fits the project and the owner. And then the nuts and bolts is the key contract provisions we'll be talking about. And really, most of them, I'm coming at it from an angle of, if they're more complex, defining, how they should be thought of and understood, some goals that the architect should have with that particular provision. And then my recommendations based on, my experience of what I think kind of the issues that architects often encounter, whether the owner is, either intentionally or unintentionally trying to take advantage, clauses to watch out for, and recommendations as to kind of how to get around that. So first of all, the necessity of a contract. I'm not going to spend a lot of time on this. I think most of us know that you do need a contract, and that's in the Practice Act, the B&P code. But there are several exemptions, and I'm not going to go through these, in detail. These are the 5 exemptions. My recommendation would be ignore these, other than number 5. I think in all cases, you would still need a contract. The one that really pops out at me, though, is the first one, and that's when you're rendering pro bono services. Of course, you can still be sued, even though you're working for free. So to me, I think you absolutely need a contract that sets out, the key terms and conditions of the project. I think the AIA, it's fair to say, agrees with me on that. They've got the B106, which is a default pro bono services contract that they offer. And, I think it's interesting. It's one of the very few, I think there's only maybe 3 architect owner contracts of the, I think there's a dozen or so, that has a limitation of liability clause as a default. So I think what you can draw from that is the AIA thinks, not only should you have a contract, but it should be a strong contract considering the risk you're taking on, in that, you're not getting paid. Some of the other provisions where the other exemptions, it's the second one is kind of a course of dealing. The third one is, just if the client says, don't worry about it, we don't need a contract. And then the fourth is more of a consultant situation. I think, I could go through those for a long time if we had unlimited time, but I think in each of those, I would strongly recommend you have a written contract, and I'll just leave it at that for now. So format, this is, some of the issues I see with clients coming to me with questions about, what should my contract look like? What form should I use if I'm using AIA? So some of the problem issues I see, a really common one is, they'll have a contract that's cobbled together from, maybe a firm they worked for, a decade ago, and then it's got a provision from, from a project that they worked on, and there was some issue that prompted them to add that provision, and then they got some legal advice, et cetera. So the end result, though, is a contract that's kind of, all over the place, and the provisions may be inconsistent or conflict, and that's a real problem. The contract, most owner architect agreements, all owner architect agreements really have to be internally consistent, because many of the provisions rely and depend on other provisions. So we'll get into that a little more in the next slide in the recommendations. Another common one, using the wrong AIA template. I think AIA contracts are great, but one thing I see frequently is, using the B101 on a small residential project. I shouldn't say frequently, but I've seen that, and it's really doesn't make sense. I mean, the B101 is, a very thorough, 20 or 30 page contract. It incorporates 30 pages of general conditions in the A201. So, using that on a small project is, I think, overwhelming and unnecessary, overwhelming to the owner, which may be a problem in terms of your relationship with the owner. And then this is just kind of a general point, provisions that aren't fully understood being incorporated into the contract. This, I think, is frequently an issue with copyright, which I'm going to talk about a little bit, and indemnity, which I'm also going to talk about. I see sometimes architects or owners, not fully understanding those provisions, and the provision will end up in there anyway, and it just won't make a lot of sense either generally or in the context of, relating to other provisions in the contract. So that's a problem that needs to be resolved. And then not recognizing the need for assistance before it's too late. So one common issue is a client will come to me and, I find out they've already negotiated 2 rounds of the contract with the owner or worse, the owner's attorney. And so at that point, it's really difficult to pull back on any provisions that have been agreed to that, may be problematic. So, just understand, when maybe you're in too deep, maybe this project is, something that you don't usually do. It's bigger than usually than your normal bread and butter project. And, in that instance, it pays to get some assistance and make sure that the contract is really buttoned up. So recommendations, I think first recommendation is, and this speaks to kind of the cobbled together contract. No one wants to work with an attorney, obviously, but it will save you time and money in the long run, in my opinion, and based on my experience. If you can work with an attorney to develop a contract that's, basically a template that you are comfortable with and that you can negotiate on your own, particularly if your bread and butter is, smaller residential or commercial projects. If you can have a narrative letter agreement with terms and conditions that you can really get your arms around, and you are able to explain to an owner, even an unsophisticated owner, I think that is really a great place to be. The benefit of that format is that it's also very attractive to the owner. Again, in that world of small residential, maybe even small commercial, the owner is not always sophisticated, is not always looking at, AIA or owner architect contracts every day. So they don't maybe know the ins and outs of indemnity or, copyright or limitation of liability that you would see with a larger project with an attorney on a larger project, or even an owner on a larger project. So that, I think, that format can be great in terms of, your client relationship. It can help, iron out the conditions of the contract, and also, can set the right tone with the client. And then the AIA documents, again, I think they're great, but you've really got to pick the right one. And you've got to customize it in most cases. So, I've just listed them there in order from kind of least complex to most complex. There's obviously, many more options depending on the project, but these are the ones that I deal with most frequently. And just understanding that going from the B104 to the B103 or 101 is a big leap, because, not only is the contract getting more complex, but, you're starting to incorporate those A201 general conditions. And that's another 30 pages of contract documentation that needs to be looked at. So just, keeping in mind that you've got to select the right AIA if that's the route you're going to go. And then understanding the need for assistance in contract negotiation. I mean, particularly if it's a larger commercial project, frequently the owner is going to have counsel. And if the owner is going to have counsel, in most cases, you should have counsel as well. So just getting into the contract provisions here, the first one, the standard of care, we all know, is the standard the architect will be held to in providing his or her services. I've listed a standard of care provision there. That's essentially the B101, which I think is a great template. So what are the issues and recommendations with the standard of care? And these first two go together. So, when you're looking at standard of care, the most common issue I see is not that the provision itself is problematic. Most of the time, even in a contract that's provided by the owner, the standard of care provision is okay. It's default B101 language or, something that's very similar to that, that's fine. Of course, that's got to be examined. If there's an issue there, I would say that's a big red flag. But the most common thing I see is that the architect is not paying attention to other areas of the contract where language may come up that could be interpreted as altering the standard of care. So, the terms I've listed here, terms like guarantee, warranty, assurance, et cetera, that type of language, even if it's not in the standard of care provision itself, it may come up later. For example, I've seen, the owner wants the architect to warrant or ensure that information provided by the owner is accurate, sort of an alteration of the right to reliance provision. That's really problematic because that's altering the standard of care. And the reason that's problematic, it's problematic in and of itself, but it's also uninsurable because, your insurer is not going to insure you for a higher standard. The insurer is not going to insure you for, perfection or for guarantees. That's not how it works. So you've just got to be very careful. If you see that kind of language, that's got to, set off an alarm bell that you've got a problem there and you've got to pull back on that. And then the standard applies not only to the work product itself, but also to timing. So a lot of times you'll see an owner have, a time is of the essence clause, and that could be interpreted as an alteration of the standard of care. He's trying to make you go, faster than you're required to perform on the project. Less frequent, but I've seen this before, language that's just kind of out there, like trust and confidence, or I've seen other kind of similar language that's not really in the same ballpark as a design professional standard of care. So just watch out for that. And then this is a little more legalistic, but you can include a clause in your contract that just reinforces that, your standard of care is what it is, and it disclaims any guarantees, warranties, or assurances. If I was putting together a letter agreement and terms and conditions, I would include that in the terms and conditions. So next topic, initial information and basic services. And this is another, I think straightforward topic that we're all very familiar with, but one that I see often is either ignored or the architect isn't taking full advantage of. And the issue here really is that the way I see this is your opportunity to really clarify, what the project is about, and to eliminate any ambiguity with the owner as to, what the project is and what you are going to be doing. So initial information, include it, provide details about what the project is, the schedule, the budget, the identity of the players, the delivery method, and then basic services. Obviously really critical how you define it. More or less critical depending on how you're being paid, I suppose, but assuming you've got a set basic services fee, critical that you define it and that you exclude additional services. So in other words, define specifically what your basic services are, and then put everything else in the bucket of supplemental or additional services. Make that distinction very clear. Again, it's an opportunity to eliminate ambiguity with respect to scope, deliverables, and responsibilities, and it establishes the basis for your fee. So recommendations. One that I've seen before is, there'll be a good basic services section, but then at the end, it will say some open-ended clause like any other services necessary to meet the owner's objectives. Well, now you've just negated, the strong scope of the strong basic services section, because you've left it open to interpretation as to what is and what is not a basic service. And then pay attention to CA. CA is, in my experience, both in contract negotiation and in litigation, it's an area where the owner, again, whether intentionally or not, there's a lot of abuse of basic services. So frequently see it as to site visits. At the beginning of the project, the owner is probably feeling great about their contractor, but then, once the contractor is actually working, they're not feeling so great. And all of a sudden they're calling you every day to come out and take a look at what the contractor just did. And, if you've got a set basic services fee, that's a real problem in terms of, the value of your time. So you've got to limit your obligation as to, and I've just listed a few there: site visits, submittal review, observation for compliance. And then anything beyond that's got to be an additional service. Relatedly, well, somewhat relatedly, same kind of idea, project completion. I mean, you've got to set, an end date at which point you're no longer in basic services, you're in additional services. So if they're calling you, a year from now to look at something, that's an additional service. And then more on the legal side, an integration clause, just, this is a clause that just says this is what it is, this agreement, what we've got right here. What we talked about at our informal meeting 6 months ago is not part of the agreement. What I put in a proposal, to do an initial, small scope or whatever is not part of this agreement. So, again, setting boundaries, basically. Supplemental and additional services. So I'm going to just touch on this because I've seen some confusion with supplemental and additional services just in terms of the definition and the difference between the two. So, and this, you can see this, I think the B101 is great on this. It defines supplemental and additional services. Supplemental is basically services that that you're going to undertake at the time you enter into the contract, but it's not included in basic services for whatever reason. There's many reasons, but the B101, again, there's a chart in section 4.1.1 that is, I think, lists like 30, categories of supplemental services. And it's just kind of a check the box format, not applicable or architect or owner or, contractor. So if you want some examples, that is a good place to go. And then, of course, additional services are services that, you don't know yet whether you will be providing them. I mean, we all know what they are, owner initiated change orders, that kind of thing. You probably know there's going to be additional services, but you just don't know, you can't put it in the contract at this point because you don't know exactly what they are or whether they will occur. So that's the difference between the two. The main point, the main recommendation here, I suppose, is if you are undertaking supplemental services, it's really critical that you discuss this with the owner up front and that you carefully define, what it is that you're doing, similar to basic services that I just talked about. But, the reason I say that is supplemental services can be a very significant scope of work. It could be architectural interior design or something like that, which is, that could be a massive amount of work. So it's got to be defined what you're doing and how you're getting paid. The B101 has like I said, they have the chart, but then in the following section, 4.1.2, there is a space for you to define, what that service will be. So, and you can obviously attach to that contract, but that's got to be utilized, because otherwise, that's just, you're just leaving yourself open to exposure for the client saying, well, you said you do, this entire scope, and there's no indication that it was limited. So just pay close attention to that. And then as to additional services, define those as those provided other than basic. And we talked about that a little bit already. If you are, doing a letter agreement, or, if you're doing a letter agreement, I've seen a tendency to try and think of all the potential additional services and list them. I think it's much better, you can list them, but don't express it as an exclusive list, and leave, a provision at the end for, any other services that may be provided that are not included in basic services, to give yourself some room there. So right to rely and exclusions. Right to rely is just, I think of this as the architect has to have some core, information from the owner that he can rely on and use. It can't all be just, the stuff that I know you often get from owners that can be very, wishy-washy. What owners sometimes do is, they kind of put it back on the architect to verify that owner supplied information. And you've got to really resist that if you can, because those issues could be outside your area of expertise. And as I say, there could be uninsurable, probably are, if they're outside of your area of expertise. And then just big picture, it's really not fair for the owner to attempt to transfer that risk to you. The owner's got to take responsibility, and if necessary, hire consultants to provide accurate information. You've got to have, core information that you can rely on. It's not really your job to take, the next step of verifying that information. And then exclusions, I'm not going to spend a lot of time on this. This could be a whole nother presentation, but, generally I'd want to see, excluding at the very least means and methods, safety and security, hazardous materials, any obligations relating to that. And that could be, very extensive, of course, depending on the project. And then work of others, kind of on the same, along the same lines of means and methods, but work of others more generally, the contractor and consultants hired directly by the owner. Okay, so this is the first topic that I think I mentioned earlier. Some of these topics I included because I see a lot of confusion. This is the first one of those, copyright. And I think that confusion is often caused by just a misunderstanding of, typically on the part of the owner, of how copyright works. So, what I see is owners frequently having an expectation that they own the copyright, the instruments of service and the copyright. And, all the more so on a unique project. And, I can understand, where they're coming from. They feel like they're paying an architect and likely other, professionals to work on this design, and therefore they should own the work product. But of course, that is not how it works. The architect is the owner of the instruments of service and copyright that he or she generates. So what are kind of the motivations here, I think is a good way of looking at this, in terms of, the architect's motivations and the owner's motivations and concerns. For the architect, I think, so this is, if you're looking at a copyright provision in a contract that, an owner has sent you, or if you're evaluating how you want your copyright provision to look. I think your primary concerns have to be, well, if the instruments of service or copyright is transferred, if that's something the owner demands of me to get the project, which is, a business decision that I totally understand. But if that's the case, I've got to find a way to retain my, my core standards, drawings, details, specs, etc. Because that's work that has been developed over the course of my career, and the owner shouldn't get that. He may get, this particular, unique design, but not all of my, my brain work product. So that's one big one. The other one is what happens if, the owner, we have a falling out, the contract's terminated, and the owner goes to another architect. What happens to my design? What happens to me then? What kind of liabilities are created? And then finally, if it's transferred, how do I get paid for that? How do I get, some leverage out of that? Is there anything I can do with that? So those are, I think, the primary, things that the architect should be thinking about. The owner, we know, is really most concerned about, his friend down the street getting the same design, you designing a house for him that looks the same, or, having some issue with you and the contract being terminated and him being able to finish the project with the same design, but, modified by another architect. I think those are really kind of the main issues the owner is thinking about when looking at copyright. So how do we resolve that? This kind of inherent tension that we have. I think the first thing is, you've got to get the owner to understand what the default is in terms of how how ownership works. This is, an issue where a lot of times it's actually easier to negotiate with an attorney than it is with an owner for that reason. But, so the first way to kind of address all of these issues is, I think, the most common way, and that is that the owner gets a non-exclusive license, which basically means the owner gets the right to use your documents for whatever, whatever purposes you list. And generally it's to complete the project, to have the contractor complete the project while you are retained as the project architect. So what do we do with that license? Well, I mean, you got to get something in return. I always think of it as kind of the default, what you would get in return. And I think the default is, at the very least, you get a release and indemnity. So if the owner goes and kind of violates your agreement and retains another architect and uses your instruments of service, you should not be, you should have a release from liability from the owner, and the owner should step into your shoes and indemnify you for any claims by any third parties relating to, that improper use of your documents. So that's what I think of as the default. You should absolutely get that, because it's only fair, and it's actually consistent with, at least as the release, it's consistent with what the Practice Act says, and the provision is there. I think it also makes sense that the license be conditioned on the owner's performance, including payment under the agreement. So if the owner doesn't pay you, then the license expires. That's eminently reasonable. But what if you have an owner that says, non-exclusive isn't enough for me. I want, an exclusive license or an assignment. Essentially, I want the plans. I want the, the copyright. And that may be the case. And again, that is commonly the case, and we deal with that. But again, going to the default, you still need to get the default. You need to get the release and the indemnity. One thing, you should think about is the transfer, limiting the transfer as much as possible. So the owner doesn't get, everything you've ever generated on the project. He gets the final versions, and he absolutely does not get your standard details, designs, etc. And then those other 3 bullet points below are similar to what we just talked about, just, conditioning transfer on performance and payment. And again, if the architect terminates, the license terminates. If the architect terminates for cause, of course, typically it's a situation where, the owner isn't paying. So that's kind of the same way of saying conditioning it on owner's payment. And then, of course, the release and indemnity. So recommendations. My main recommendation here, and this is, unfortunately, I see this a lot, is, an architect saying, well, I'm not going to be, designing a project like this again. So the copyright isn't really that critical for me. And, that's fine. If you have to give a little to get the project, copyright may be the area where you look to. And again, that's, I'm not one to say not to do that. That's a business decision. But what I don't like to see is architects not recognizing kind of the importance, the value of the copyright as an asset. The owner doesn't know that you think that it's not as important, or, that you're willing to concede it so easily. So, ideally you can use that to get something in return, either in the copyright section. I mean, like I said, again, you've got to get the default, but maybe it comes into play in some other, aspect of the contract. And this is something where, in more complex contracts, this happens all the time. Okay, you gave me the copyright, so I'm going to give you, a waiver of consequential damages, or whatever the case may be. It's a tit for tat. So that's got to be, something you've got in the back of your mind. And then, the last 2, this is kind of a little bit different twist. If you're the architect that's coming on the project, taking over for another architect, now you've got a lot of concern that, that first architect, what's going on with his copyright? Does the owner really own what he's giving me to do this project? So you've got to be really careful there. You need a strong disclaimer. The elements essentially are, the owner has to represent that he owns the documents. He has to be able to verify that to you. And he's got to be willing to indemnify you, to step inside your shoes if, there is a claim from a third party, or, the prior architect. So next topic, limitation of liability. This is a big one. Of course, the default is that an architect has unlimited liability. If he is, if he is insured, that's great, but liability can exceed insurance. So the architect needs a carefully drafted, reasonable limitation of liability clause. And we're going to talk a little bit about what that looks like. So 2 issues here in terms of what is reasonable, and that's what the courts require. There is a procedural side and a substantive side. The procedural side is easier. It's got to be, the clause has to be clearly delineated, which is typically viewed for some reason as all caps, even though I think all caps is a lot harder to read than, bold or italics or whatever, but it's, they're always in all caps. And the client should separately initial the provision to indicate express agreement. So there's a little, there's a little space for the client to sign or initial underneath that specific provision. More importantly, substantively, it's got to be reasonable. And we don't really know a whole lot about what that means. There's no set formula, but it's kind of just a common sense issue. One thing I would say is consider the project cost and notice to the owner. So, frequently We use insurance proceeds as an element of a limitation of liability. I think that is, really works well because it can essentially limit the architect's liability to their insurance deductible. And on a big project, that may make a lot of sense. And we use available insurance proceeds rather than the insurance limit or something along those lines, because your insurance policy is likely a declining limits policy, meaning that if you had another claim, or if attorney's fees on this present claim have, they will reduce the available insurance money. So it's got to be phrased as available insurance proceeds. Otherwise, you're going to have liability for the difference between the limit and the proceeds potentially. But that is, that's, I think, probably the best way to work with limitation of liability. Typically on a bigger project, or maybe even on a smaller project, I see a lot of clauses where the architect's fees are used. And generally, I think that's probably not going to be considered reasonable by a court. The reason that the insurance is a nice way to go as well is because if the client knows your insurance policy through the contract, then he can't really argue that, he didn't have notice of what it was. So he's got it right there in front of him. Okay, he's got $1 million in insurance, and I'm going to get most of that if there's a big claim. It kind of makes it a little clearer in terms of getting to a reasonable clause. And then this is just a kind of more legal side, an introductory clause justifying its purpose. Most of the clauses I see have these, but tying the risk to the amount of fees. So if you didn't have the limitation of liability clause, in other words, your fees would have to be higher. Make that clear at the in the intro to the limitation of liability clause. And then also, if you're providing services through a corporation, which I would recommend, you can try and limit your individual liability or disclaim individual liability by including a clause that recourse, the client has recourse against the corporation only. The corporation is the insured party. The client can go after the corporation, but he can't go after the architect's personal assets or the architect at all individually. So consequential damages, and this may be the last one I can get to. Got a little bit of a time limit here, but this is related to limitation of liability, so maybe it's a good stopping point. Consequential damages, what are they? First of all, you've got direct damages. Damages are flowing directly from an error caused by an architect. For example, a cost to rebuild a structure that's damaged as a result of a design error. Consequential damages, a little bit different. They're indirect. So, if you're designing a hotel, for example, and, part of the hotel collapses because of a design error, then you could be liable for, the lost profits from the, renting of those rooms, that kind of thing. So it's not a direct damage. It's something that's a consequence of the negligence. And you may be liable for consequential damages if they were reasonably foreseeable at the time of the entering into the contract. And obviously that's going to, in most cases, that's going to be a big number. So got to be careful. So what do we need? And these are frequently, we need a waiver of consequential damages. And these are frequently negotiated alongside limitation of liability clauses. So, obviously, if you can't get a waiver of consequential damages, then all of a sudden your limitation clause is a lot more important, and really vice versa, because if you can't get a limitation, then you need to try and eliminate consequential damages, because that can be a big number. And they're particularly relevant in delay claims, which are, prevalent. if the architect's error causes an extension of the project schedule. And this just, I've got a note there, emphasizes the importance of, having some protection in your contract for adjustment to the schedule. I would recommend a force majeure clause, which basically says, essentially, you're not going to be liable for acts of God. We saw that with COVID-19, huge issues there in terms of delay. And then, the ideal is that you can disclaim liability for consequential damages generally, and specifically for delays relating to public agency review. I mean, that is a huge one. Try and get a client to agree with you that the delay is attributable to a public agency and not to an architect after, the project has gone south. And that's one I see, all the time. So, and then to suspension of services for non-payment or termination of the agreement. You don't want to be, liable for delays during that period of time. So this may be a good stopping point, Tim, if we've got questions.
Yeah, great. Yeah, there's obviously a great presentation. Thank you, Jonathan. A lot to digest there in terms of going over just key points and the outline of such a topic that, like you said earlier, could be discussed for hours or even days in terms of a seminar. So thank you for creating this abbreviated version of that. And we do want to open it up to questions right now. We've got about 10 minutes. I got a couple in the chat, but if anybody wants to kind of chime in here, feel free to unmute yourself and turn on your camera if you want to, and go ahead.
This is Frank Jesse. I have a quick question. I'd love to have just a little more detail on the downsides of limiting to the fees the architect fees. I'd love to hear a little bit more on that, because I've used that provision a good bit and I just wasn't aware that there was some real risks around that.
Yeah, well, and thanks for the question, Frank. You've just got to keep in mind that a court has to agree with you that that's a reasonable limitation. And if the court says, no, that's not reasonable, then you no longer have a limitation. So you're opening yourself up to some risk. I mean, I get there's always a desire on the front end when you're putting these clauses together to say, oh, I want to get it as low as possible, especially, maybe you're not, I mean, I don't know your situation, but, if someone's doesn't have insurance, you definitely want to get it as low as you can. And the fees may be a touch point, but it's better to be, quote, reasonable, to make it a little higher, to give yourself some room, and to be able to argue to the court, that's reasonable. Now, it also depends on the project value and what the fee is. I mean, if the fee is 10% of the project value, that may be reasonable. The court may say, yeah, that's reasonable. There's not a lot of clarity on that, unfortunately.
I see.
So, when the reason I said, I referenced the insurance deductible, I mean, that could be, depending on what your deductible is, of course, that could be an amount that's similar to your fee on a given project, in which case I would absolutely utilize the insurance, because it just, it makes sense. You've got a much better chance of getting a judge to agree that your insurance proceeds are reasonable than your fee, because again, the client is going to know up front, likely. I mean, if you put it in your contract, or if you tell them, I would recommend it, being in there. It would be in a B101. The client is going to know what that policy is, so they can't exactly say, well, they don't have much of a leg to stand on arguing that it's not reasonable.
My keen concern that occurred on a project was I had a fine relationship with the client, but it was in a healthcare environment. And my concern was third parties that might have some issue with the resultant healthcare project. and be suing everybody and their mother. And so I limited my liability in writing with that healthcare organization for fees paid plus a sum above that. And I can't recall the exact number, but it was something like $100,000. And so that's the way I was trying to cap it when I wasn't covered by insurance on that project.
Yeah, that makes, I mean, I see those formulas a lot, and sometimes, they can really make sense. But again, I think it's overall going to be tied to the value of the project and, the risk. If you've got a lot of third-party risk, and that's going to be a consideration. But I think those formulas can work. It's just, it's gets a little more complicated.
And more risk can put into it. Yeah.
Mhm.
Hey, Jonathan, Phil Rossington here. What about consultant limitation liability? Speaking of structural engineers in particular, I received a proposal for like a $1.5 million house where this engineer tries to limit his liability to $10,000, which, is about what his fee is, but obviously that's not going to be enough for anything that might happen due to, his negligence or whatever. So is it also, are they also considered professionals like architects and have the same, reasonableness attributed to their liabilities?
Yes, and what I would see frequently on that, it would be that it would just flow down, that provision. So if you had a provision, it would flow down in the same way to his.
Well, in this case, he's not going through my office. He's contracted directly to the owner.
I see. Okay. Yeah, same considerations for him.
Yeah.
So I think he has a serious concern that, $10,000, I don't know what the project value is, but
5 million, so
yeah, that's not going to work.
yeah. Okay.
No.
Okay. Thank you.
Yeah, absolutely.
Anybody else have any questions for Jonathan?
Well, without taking intellectual property away from Jonathan, I'd love to have a copy of this presentation.
Yes, and please feel free to reach out to Jonathan. I dropped his contact information in the chat, or I think Sydney or I can get that to you. We talked to Jonathan earlier today. He seems like that's okay, and just correct me if I'm wrong. I know that this presentation is recorded and will be available on YouTube shortly. So that's two ways I think we can get you the slides.
That's excellent.
Yep.
Yeah, and there are a few more, just so you know. So we didn't get into indemnity, which is actually hugely important. And we didn't get into suspension and termination rights and dispute resolution. So all three of those, I think, are, obviously come up a lot. And I'd love to go through them with you guys maybe another time, or if you want to reach out, we can discuss, and I'm happy to give you the slides, Frank.
Thank you.
Yeah, I think we gotta maybe do a part 2 of this seminar here, this lecture series, because it's it's got a lot of information in it, and the last 3 topics you just showed, obviously have some relevant importance as well. So we'll have to schedule that here in the next couple of weeks. Any other final comments or thoughts from the audience? I've got one question that I wanted to hit on. When you talk about instruments and services, defining it as the final plans or the specifications. What are your thoughts on deliverables? Electronic drawings and those kinds of things. Is that something that's recommended to do for clients, or is it should we just keep it more to like PDFs or hard copies?
Like BIM.
Yeah, exactly. Yeah, Revit files or CAD files or
Yeah.
whatever media you work in. Is that something, because I feel like from a client's perspective, that's an opportunity for them to maybe pass that on to another architect who might be doing a project in the future for them that they could use as a starting point, and just doesn't seem fair.
Yeah. So I guess the short answer is it's kind of too long of a topic to get into, but remember going to an AIA seminar a while back, and they recommended, that should be really the subject of a separate agreement as to how, electronic documents are going to be handled. Now, today, obviously, more often than not, you're going to, if you have an agreement where the client's getting that stuff, you're going to send them an email with a link. You're not really going to probably be dealing too much with hard copy anymore. So that's the issue. They can easily copy that and then, send it to whoever they want. But the same, fundamental principles apply. Just because it's a little easier, doesn't mean that they're off the hook, obviously. And, the key touch point really is going to be, one of the touch points, but, when that claim comes in, if, God forbid that claim comes in from a third party, now what happened, and you've got to enforce that indemnity and release provision.
Okay. Yeah, I just see that happening more often than not, where clients will think that they own your drawings and will, give that to the next architect and say, hey, here's an opportunity for you to, start a project with us, and we've got drawings from the last project we did. So just a tough situation to be in.
Yeah, you got to get that release and indemnity.
Right.
And, sometimes there will be, look, these were kind of the basics today, but, sometimes there'll be fees, termination fees, of course, and, it can get very complicated. And depending on the size of the project, that, may or may not make sense. How much do you want to spend on legal and all of that, but it gets quite a bit more complicated, obviously, as you guys know.
Okay, anybody else? We do want to be mindful of everybody's time here, and we're at 1 o'clock. So again, we've got Jonathan, his contact information in the chat here if you want to reach out to him after the presentation or access the slides. We'll be sending out a link to all the participants here for the video, but a big thank you to you, Jonathan, for joining us today and giving us just a presentation that, really just helps educate us and going forward with our practices and learning about contracts. Something that, like I said earlier, just we don't have an opportunity to focus on a lot because we're just so engaged in design and construction and developing marketing and those kinds of things. It just seems like, as architects, we just reuse a lot of the contracts we have, but we need to be aware of, what that sets us up for, and the liabilities and the risks associated with that. So if anybody has any AIA contract questions or anything like that, I know our office, our East Bay chapter office is happy to help you with any AIA contract, whether putting that together or helping you set something up as well. But Jonathan, what a great resource, and thank you again for joining us today.
Absolutely, my pleasure. Thanks, guys.
All right.
Thank you,
everybody. Thank you, everybody, for joining us. All right.
Thank you. Thank you.